It's March 4th, but we are on the countdown to the Karen Read trial. And in the run-up to the Karen Read trial, there are going to be a lot more court hearings.
Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion. And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me make crystal clear, they made clear that I could inform the court there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed, it is over. So all those implications and innuendos that erode at the objectivity of our potential jury pool, well, they become more egregious when you see that they're not based on reality or fact.
So it's over. I had been waiting to see if there was going to be official word, and there it is. We were told last week that he was going to say this in court. How did the media know last week that Brennan was going to talk about the federal investigation in court? How did anyone know what he was going to say?
You called that a pause email, but when I was looking through my notes, what you said was, based on that pause email, I infer that there was no further discussion between ARCCA and Mr. Jackson regarding compensation and retainer, and then out of the blue, the bill arrives. So my question to you is, are you inferring or do you know that to be fact, that there was no conversation, emails, texts, letters, phone calls? Do you know that to be fact, or is that what you are inferring, as you said?
Oh boy.
I am inferring, Your Honor. I do not know that as a fact.
Okay. So now my next question is...
That's why he said I infer.
Regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025.
To the defense.
Provided to
No, to the Commonwealth, from the defense.
The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time?
Same time as what, Your Honor?
As the invoice.
Oh boy.
And you're referring to the record of payment being...
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court,
It's a fair
until
question.
I asked you midway through your proceedings.
It's a fair
In fact,
question.
I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. It seems pretty clear. This was filed, I believe, in the weekend, February 16th. In the Commonwealth's defendant's opposition to the Commonwealth's motion to exclude employees of ARCCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and a desperate and transparent.
The court does not, I think, at this point, have a lot of faith in what the attorneys represent to her. And that's a problem.
Attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense related to the ARCCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
Yikes.
I'm going to answer it, Your Honor. I just want to make sure you were finished with your
Go ahead.
question. I learned that that invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned.
You don't have to
I'm sorry.
repeat it. And again, what you know and what all the council know is one and the same.
I understand, Your Honor. I want to, so I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through, and when I got to the invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But the motion, defendant's opposition to the Commonwealth's motion to exclude employees of ARCCA is signed by you.
Your Honor, it is signed by me, but if I could with regard to 3.3A1. 3.3A1 is not a strict liability statute. That's the reason why it has knowing in it, is in order to violate 3.3A1, the attorney in question has to know with regard to the fact and issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works.
Correct.
I am responsible for everybody. But, Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis and construction, Your Honor, would render mere surplusage and read out the mens rea of knowing. In something that critical of candor to the court, that's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3A from everything else in the world, which I agree completely with Your Honor.
Well, today in the Karen Reed case was quite a lot. It's Tuesday, March 4th, and they ran about a half day of court today. As you will remember, the defense filed their motion for a brief continuance with regard to the motion to dismiss, and it seems that with today's half day of court, that's going to be taken up tomorrow after federal court. So tomorrow around 11 a.m. Eastern is when court should begin to hear argument on the motion to dismiss and one more motion with regard to the Commonwealth's expert from the defense's side. And then Ms. Little has recently filed a motion to reconsider the defense's request for metadata. So those are the three things on the docket for tomorrow. The court also extended the deadline for the motions in limine. Those are going to be argued on March 18th. The motions in limine are those pre-trial motions about what evidence will come in, what evidence won't come in. So that day, the 18th, will be a full day of court arguing those motions. So those are going to be due on Monday, and then those will be argued following that. But it's what we see ahead of trial in every case. And then they're just not even weeks out from jury selection beginning on April 1st. So all things considered, this case is on track to start jury selection April 1st. It'll probably take a week of jury selection given the publicity of this case, but it's supposed to be a shorter trial. We will see. Tomorrow in court, there is the habeas petition argument in federal court. I've covered the defense's petition. I did not have a chance to go over the Commonwealth response more thoroughly. It is very similar arguments to what we saw before the Supreme Judicial Court, but it's taking it up the federal track to say that Karen Reed's rights have been violated by the court declaring a mistrial when the court should have given the option for the jury to enter their verdicts of counts 1 and 3. But the jury did not indicate in their notes that they had verdicts on counts 1 and 3. So the manifest necessity for a mistrial is going to be the core of the defense argument. They are trying to, at a minimum, be allowed to interview the jurors about whether they reached verdicts so that Karen Reed is not retried on those 2 counts when the jury says, or at least some of the jury members say, they came back with verdicts on those counts and didn't know they could enter a partial verdict, meaning on 2 of the counts, not all 3. And that it violates Karen Reed's double jeopardy to go ahead with that retrial. We went over some of the case law that was cited by the defense in this. The Supreme Judicial Court has said that in the court's discretion, the court did not violate their discretion in finding there was a manifest necessity to declare a mistrial, that the notes from the jurors were clear, and therefore the Supreme Judicial Court in Massachusetts did not find any error in the prior ruling. They are now taking this into the federal system, and there will be argument on that tomorrow. That will not be streamed. It is open for the public on a first come, first seated in federal court there in Boston. And then all the defense attorneys will be back over in state court in front of Judge Cannone. But today, the court started off with, I have a few more questions about paying the ARCCA experts. And that included questions about Attorney Little's filing to the court that corrected the defense opposition to the Commonwealth's motion to exclude the ARCCA experts due to failure to meet the discovery obligations. And Ms. Little corrected, saying we stated in our opposition, which they did, that they did not pay the ARCCA experts. And she said, no, we in fact reimbursed them. I think they paid them. It's not really a reimbursement for fees. They paid them for their time. Again, there's not a problem in paying an expert for their time. That's not the issue. The issue is, was it represented to the court differently? And the court came out today with a bunch of questions about that, saying when the invoice from ARCCA was turned over to the defense in discovery, why wasn't the payment to ARCCA of that invoice also disclosed? And the court did not seem pleased about the fact that the payment was not disclosed, and in fact asked Attorney Alessi, and it wasn't even brought up until halfway through your presentation to the court, to which Alessi responded, Your Honor, I was going in chronological order. So in the chronology, we hadn't gotten there yet. And in fact, I didn't know that there was payment made to the ARCCA experts until Sunday before we were in court on Tuesday. But the representations of Alan Jackson at sidebar about not paying the ARCCA experts, the representation in the defense's filed motion that they did not pay the ARCCA experts really is the sticking point here, because they paid the ARCCA experts. They didn't hire them, but they did in fact pay them. But will this impact the ARCCA experts' testimony at trial? Unlikely. They will still be allowed to testify, and then the Commonwealth will say, and have you testified before, and were you paid for your time? Yes. Okay. Every expert ever. They're going to ask the Commonwealth experts that, and the Commonwealth experts have been paid. So it's the issue of how and when it was represented to the court. And then we got into a extensive motion later in the morning from the Commonwealth on a motion for sanctions against the defense for violating a protective order with their motion for reconsideration, wherein they included testimony of a juvenile witness and statements made via text message between Trooper Proctor and ADA Adam Lally. When Yannetti responded to that, he said, this was my error. These things, I didn't think they were covered by the protective order. When I went back and looked at the protective order, it's clear that they were. But Attorney Yannetti did not file with the court a correction, which I think is also going to be a problem for the court. But then the Commonwealth went way beyond their filed motion and argued that the defense has been essentially on a PR tour and that there should be a full gag order in this case. That's being taken under consideration. But in the middle of that argument, we get the Commonwealth coming in and saying that Attorney Little is talking about this, federal investigation. And then there's an implication that the elected DA Morrissey is the target of the federal investigation, and that other members of the defense team had said that on television earlier on in this case, and that there isn't any longer a federal investigation. But the way he presented it, he seemed to indicate that Attorney Little represented to the court that the federal investigation was ongoing when she knew that it wasn't. And then we get up and go through the fucking timeline, receipts, everything. And the timeline is that Attorney Little argued that in court on February 18th. The Commonwealth was told that the federal investigation was over on February 19th. And the Commonwealth disclosed that to the defense on February 26th. So when Attorney Little stood up in court and said, and there's an ongoing federal investigation, and talked about the ongoing federal investigation, to the best of anyone's knowledge on February 18th, that was true. And I think, again, Brennan implicated that when she made that statement, it was not accurate. But then when he broke down the timeline, it was, which harkens back to the last hearing when Brennan's like, I got all these things from the federal government, and then had to come back into court and say, no, wait, those actually came from the defense. Where I have grace for there are times people misspeak in court, when it starts to become the pattern of speaking in court, I start to have greater concerns. So I want to see the receipts, the timelines, everything, because the impression that I was left with listening to this in real time was that somehow the defense had represented something wrongly. And what we've seen over the last few weeks is that the defense has had to correct themselves a number of times because they have represented things to the court. We have not seen the defense file for motions against the Commonwealth for the same. And those seem to be corrected in court in real time, but they're still getting corrected. And it's an issue that this has gotten so wild with the way things are being alleged in court. And I don't think it's going to tone down before trial. This seems like the retrial is going to be a trial where we have objections during opening statements, closing arguments, and all the rest of it. It is going to be hard fought. And it's going to be difficult, I think, for the attorneys to have, at some point, some type of collegiality. So what we learned, though, is that the federal investigation is over. We have seen that there's been no indictments, so it means there are not going to be any indictments. And the federal investigation into whatever they were investigating with the Karen Reed case is done. So now where do we go? Well, we go to a retrial, and the ARCCA witnesses aren't as restrained, but the jury is still potentially going to have to grapple with, well, in this prior proceeding, in that prior proceeding, because when we get to this second trial, which I think we will, when we get to this second trial, there are witness statements to law enforcement, to a state level grand jury, to a federal grand jury during the first trial. And that's if there's only one statement to law enforcement. So we have witnesses that are going to come into this who have testified at possibly 3 prior proceedings, plus given statements. It is going to get messy. And we're going to see a lot of in prior proceeding on this date, didn't you say? Buckle up. There's going to be a lot that's going to happen in court between now and the beginning of April when this case starts. And I'm going to try to keep you in the loop on all of it. But it looks like this trial is going to go ahead. And I will be surprised truly if it doesn't. I think there are considerations in the motion to dismiss. I also think the case law is a very, very high burden to meet for the defense, which I broke down on this week's Emily Show. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.